Thank you, Council President. All right, so this legislation addresses some issues that we identified as we were going through the process of our zoning policy process, but we could not include them in a zoning text amendment because they are issues that are in the legal code and they require legislation. So we had to put them in the parking lot, so to speak, and plan to introduce them later. Just wanted to be clear about that because there was some confusion as to whether we were revising the proposal that we previously passed. We're not revising this proposal at all. We are simply addressing some issues that are in a parallel code that we were not able to reach into with our previous zoning change. And so the elements of this bill, I think, are pretty well known, but the first and most controversial, I'm sure, is replacing the phrase accessory apartment with accessory dwelling unit. And there's actually a reason for that. We're trying to be part of creating a national standard for the terminology. The second provision of it is to address the standards for minimum ceiling heights for basements and cellars. There's a point of clarification that Jeff will espouse here, but the basic issue is in an existing basement, in a basement, we want to allow the ceiling height to be as low as 6'8". But if there is a intrusion such as a duct or a beam, it could be 6'4". And we hope that will allow some homeowners in older houses to convert their basement units without having to excavate the basement, which would be fairly prohibitive, I'm sure, for most. So there was a little confusion about that. We were not intending to apply the 6'8" height to any other level of a house, strictly to the basement, and that is what the committee was recommending. Jeff, was there any other clarification needed?
Yeah, it's just that the 2018 International Building Code only allows 6'8" in a basement and doesn't allow it in stories above. What the bill is addressing is what you define as habitable space. So it will not override the International Building Code when it comes to new construction, but if there is existing space of that height, which may include some buildings built before 1958, it would allow that to be habitable space.
Right. I think exactly. All right. Another element is requiring that the applicant for a license certify that they are indeed allowed to have a unit according to their common ownership associations. It is a reality that some HOAs or condo associations, I guess it would be really HOAs, don't allow their residents, the homeowners, to have one. And then we have a provision in there around reporting so that we can just get a steady flow of information about the adoption of this type of housing. Was there another element of the legislation, Jeff?
Just to say that we don't want there to be any implication that the county will enforce an HOA's covenants, but just that we want to put the builder of the ADU on notice that there is an HOA, and the HOA on notice that there's an application for this. But it is not the implication that the county will enforce.
All right, so those are the main provisions of the legislation. I appreciate all of the effort that went into this from my colleagues, and I think the process of broadly legalizing accessory dwelling units has been a very helpful conversation about the county's approach to housing and our different ways that we can address the affordability problems that our residents are having. So that is our committee recommendation, and I appreciate my council colleagues' consideration.